Fourthly, the Criminal Procedure Act introduces a whole range of procedures that are designed to effect more efficient and effective case management. Case management tends to be a dirty word with defence lawyers, and I just need to stress that what I mean by case management, and it's a convenient phrase to capture this, is simply discussions between the parties to resolve issues that need to be resolved in between court hearings. So there's generally in the Act an obligation on the parties to progress matters out of court. There's an expectation that there will be better communication between prosecutors and defence counsel. If there is a not guilty plea, the parties are required to talk to each other and to see if the case can be resolved by an amendment to the charges of the summary of facts, or by a withdrawal of one of the charges and guilty pleas on the other, and so on. And that will then result in a memorandum that's filed in court. Cases will only go back before a judge if some sort of judicial intervention is required, a sentence indication, some problem with disclosure, issues about admissibility of evidence, or whatever. So the Act specifically prescribes that judges are not to be case managers. Do not use judges paid $400,000 a year simply to administer cases. We employ judges and pay them lots of money to make decisions, and their role ought to be confined to that. There are more generally processes to facilitate early resolution, identify issues in dispute, provision for that in the case management memorandum, and therefore reduce the number of trials that fall over at the last minute. And incidentally, a lot of these processes, before we put them in legislation, we trialled for a couple of years in Tauranga and Manukau, and in the light of experience, we modified them quite significantly in discussions with prosecutors, defence counsel and judges in those areas that formed the basis for what's in the Act. Actually there is now data that shows that those practices that we put in place, even without a legislative framework in Manukau and Tauranga, have reduced the number of trials that fall over at the last moment. There are some incentives and sanctions in the Act to encourage compliance. In particular, there is provision for costs to be imposed on the parties if they fail to do what they're required to do, including the prosecutor and including defence counsel as distinct from defendant, which you can imagine they don't like very much. And there are also provisions that allow either a discount on sentence if the defendant has cooperated to expedite the process, so the equivalent of the discount for the guilty plea, or provision to treat deliberate delay and failure to do things as an aggravating factor. In other words, you can treat as an aggravating factor the fact that the defendant has failed to turn up without reasonable excuse on multiple occasions. Now, all of that stuff obviously depends upon a culture change. The legislation can't do anything except set the framework. So what we have to do here as well is implement this so that everyone actually changes simply the way they operate. It remains to be seen whether that will be successful. Fifthly, there is a change in the legislation to the jury trial threshold, so that it is now shifted to 2 years or more. The prosecution will no longer be able to choose the form of trial by reference to the way in which they lay the charge, apart from very few offences at the top end, The question about whether it's a jury trial or a judge-alone trial is solely a question for the defence, and the defence can only elect if the maximum penalty is 2 years or more. The original bill before Parliament, as you probably will recall from all the publicity, actually shifted it to offences of more than 3 years. As a result of particularly pressure from the ACT Party, who were got to by some defence counsel who shall remain nameless, the government changed it back to 2 years or more. Now, actually, there was a very good reason why it was more than 3 years, which unfortunately that change has removed. And the very good reason was that more than 3 years took out all of the domestics that did not result in injuring with intent charges. So it took out male assault, female, common assault, assault with intent to injure. And those are the cases where the fact that you can elect jury trial is a major opportunity for delay, because jury trials take longer inevitably because issues that in judge-alone trials are dealt with at trial often have to be dealt with before trial. The fact that you can elect jury trial in domestics means that there are significant proportions of elections simply in the hope that the complainant will change her mind and they'll get reconciled. In the event the complainant turns up at trial and is going to give evidence that she was going to give, the defendant changes the plea at the last moment. So there was a very good reason why the threshold was chosen, but anyway, that the politicians chose to ignore. So what are the benefits of all of that? Well, obviously there are intangible benefits in terms of quality of justice, and there are also tangible benefits in terms of earlier resolution, fewer court events, shorter trials, and in the case of the police alternative resolution scheme, more cases disposed of without court proceedings at all. So that's the current reforms. Let me just briefly touch on whether there is a need for more fundamental reform, and then we can stop and have a discussion about it. The Law Commission in mid-February put out a consultation paper that was entitled Alternative Models for Prosecuting and Trying Criminal Cases. That's online there if you haven't looked at it and you're interested in looking at it. Submissions closed at the end of April, and I don't know what's happening with it at the moment because I'm not there anymore, but anyway. That was a paper that came out of a piece of work that the government asked us to do, particularly following the Clinton, Shipton, Sholem sex offence trials involving Louise Nicholas. And we were asked originally to look at whether the law should be changed around the admissibility of previous convictions in criminal cases. And we took the view that because the Evidence Act had recently come in and the law had already changed, it would be premature to make any further changes to that until we saw how it was working. But what we did say was that, in our view, from all the feedback we'd had, there were more fundamental issues about the way in which criminal trials operated, particularly in sex offence cases, and we ought to have a look at it. The government duly gave us a reference. Task Force on Sexual Violence made a similar recommendation, so we're acting on that as well. And we spent a couple of years looking at whether we should change the way we operate the system pre-trial and trial, both for sex offences and perhaps more generally. And we did that particularly by reference to inquisitorial models. And I did have the I suppose the fortune is spending about 3 weeks travelling around Europe, visiting a number of jurisdictions and looking at the way their systems operated, including sitting right through trials and talking to judges and prosecutors and defence counsel, having the proceedings translated for us, and so on, which was actually one of the most fascinating 3 weeks I had spent in my career in the justice system. And for the first time in my entire life, actually gave me an understanding of how inquisitorial models operated. So some of what's in that discussion paper reflects that experience. None of it reflects any final thinking by either me or by the Law Commission. They were simply some ideas that we put out to prompt public discussion. We did, in the discussion paper, say that we thought there were a number of problems with our current processes even after the Criminal Procedure Act. The first and most fundamental, perhaps, is that the prosecutor and the defence in an adversary system are largely in control of the process. They are the ones that determine the issues. They are the ones that determine what evidence is to be called. If you think about it, there is something deeply counterintuitive about this. Can you think of any other area of human life, I've tried and I can't actually, where a person who is required to make a decision is not in control of the information that they get in order to make that decision? Can't think of any other area. We operate a system where people are expected, whether judge or jury, to make critical decisions about people's lives, but they are not able to determine what information they need in order to make that decision. They are powerless. They are dependent upon what the parties choose to put to them, and they're dependent upon the way in which the parties choose to put it to you. Now, whether that's right or wrong, it is actually, when you think about it, a little strange. Secondly, of course, the adversary system that the parties do run allows confrontational and aggressive evidence through cross-examination, because we believe that the best way of testing the veracity of evidence is through cross-examination rather than through some other process. Now, I actually don't know of any evidence that that is in fact the case. And of course, in European jurisdictions, by and large, cross-examination as we know it is unknown. It is beginning to creep in because of the influence of Anglo-American TV drama programs that lawyers in Germany and the like watch, and it's much to the consternation of judges that this is creeping up. But actually, generally, in their legal culture, even although counsel can question to some degree, cross-examination in the form in which we do it is not something that they're at all used to. Cross-examination, of course, as Catherine Ryan said to me when she was interviewing me about this on 9-9, can throw light into dark corners. But as I responded, it much more often throws darkness into light corners. It confuses and obscures the evidence, and indeed that is what it's designed often to do, particularly if you don't really have a defence.